I want to start by thanking Patrice Payne and her team at the ABA for organizing today's program and to the panelists for joining. As is often the case when one administration ends and all eyes turn to the next, there are questions about whether enforcement trends established in the outgoing administration will persist or whether there'll be a shift in enforcement policy or focus and what those changes might look like. I think it's fair to say that there's an expectation that white collar enforcement activity in general will likely increase in the next 4 years, but beyond that, it's always a bit of reading tea leaves. Fortunately for us, we have an all-star panel today to help us read some of those tea leaves and to discuss potential enforcement trends going forward and what clients can now do to prepare themselves. Let me briefly introduce our panel. We have Kendall Day, who is a partner at Gibson, Dunn, and a member of the firm's white collar defense and investigations and financial institutions practice groups. Among other things, Kendall specializes in handling criminal, regulatory, and civil enforcement actions involving various anti-money laundering issues. Prior to joining Gibson, Kendall held several senior positions at the Justice Department, including having served as chief of DOJ's money laundering and asset recovery section. Next is Steve Fagell, who co-chairs Covington and Burling's white collar defense and investigations practice, where, among other things, Steve specializes in advising multinational companies in FCPA civil and criminal enforcement matters. Previously, Steve served in the Department of Justice as a senior key advisor to the head of the criminal division. Next, we have Lisa Phelan, who co-chairs Morrison Foerster's global antitrust practice. With more than 25 years of service in DOJ's antitrust division, Lisa is one of the leading authorities in criminal antitrust matters. And last, but certainly not least, we have Chris Babbitt, who is a partner at Wilmer. Chris co-chairs the firm's False Claims Act practice and has significant experience defending companies in nearly every industry in various FCA matters. I thought we might kick off the discussion by talking about some of the recent legislation that could impact white collar enforcement over the next 4 years. At the start of this year, Congress passed new anti-money laundering legislation. Kendall, I'd be interested in your thoughts on the new law and how you see it impacting DOJ's AML enforcement efforts.
Sure, Justin, thank you. And thanks to Patrice and the ABA for hosting this event. As many of the folks watching this will know, the Anti-Money Laundering Act of 2020 was passed as part of the National Defense Authorization Act. That was the defense authorization bill that was passed over a presidential veto. In short, the Anti-Money Laundering Act has the most comprehensive set of reforms to anti-money laundering laws that we've seen in this country since the Patriot Act was passed in 2001. There are a number of important changes that will affect and likely increase DOJ's enforcement of anti-money laundering. Several of these are so significant, I think we might even turn to them later, such as expanded provisions for whistleblowers and the ability of U.S. prosecutors to target and obtain foreign bank records. I don't want to steal the thunder from those areas, and I'm sure everyone is on the edge of their seats to hear more about them. But there are some other provisions that I think are also notable, although haven't necessarily been getting quite as much coverage. One is the fact that the Bank Secrecy Act, which is the umbrella legislation for the U.S. anti-money laundering laws, that has now been expanded to specifically apply to things like cryptocurrency and other non-traditional value transfers. And that's important because, in the past, the regulators such as FinCEN and others have essentially taken the position through guidance that the Bank Secrecy Act and regulations apply, but it was a little bit of the problem of a square peg in a round hole. It was difficult because some of those regulations were written in an analog time to take them and apply them in a digital age, right? Like think about OFAC regulations about what you do when as a financial institution, you identify sanctioned property. You're supposed to block it, segregate it, and put it in an interest-bearing account. Those concepts don't really exist in crypto. So, the application, the specific application by statute of the Bank Secrecy Act to non-traditional value forms will likely increase DOJ attention in this area. There are also enhanced penalties, right? The Act, among its many provisions, includes enhanced penalties for repeat violators of the Bank Secrecy Act. That might not affect the pace of enforcement, but it could impact the final results of an enforcement matter. If a company or a person has previously violated the BSA, the resulting penalty can include civil penalties that are now 3 times the greater of the profit gained or the loss avoided, or 2 times the maximum statutory offense. So those kind of recidivist penalties could matter to the outcome of a particular enforcement action. And then the final thing I would note, just in terms of particularly affecting enforcement, are more international personnel, particularly for FinCEN. That's not a DOJ authority, right? The Financial Crimes Enforcement Network is in Treasury, obviously. But anytime there is more connectivity internationally between governments that are focused on a problem set like this, money laundering, I think the result is going to be more cases brought by the Justice Department. More tips, more investigative leads, more access to informal evidence sharing, not necessarily formal evidence sharing through the MLAT process, but the informal evidence sharing that might not be admissible in court, but is enough to allow DOJ to advance an investigation.
Thanks, Kendall. On the FCPA front, we've all seen reporting suggesting that there was a decline in new FCPA investigations under the prior administration. Steve, I wanted to ask you from your perspective, has there been reduced FCPA enforcement activity? And if so, and what do you attribute that to? And do you expect an increase under the new administration?
Thanks, Justin. So I would say that from my days in the criminal division at the department to now, my perspective has been that if a particular unit or section or component of DOJ is well resourced in headcount and funding, cases generally follow. And the FCPA unit remains well resourced, well funded, and cases are still being investigated and they're being brought. In any enforcement program, there are going to be ebbs and flows, but the cycle of FCPA has shown that it remains a very institutionalized and robust enforcement program within the department. And if Dan Kahn, the acting chief of the fraud section, or Rob Zink, the former chief of the section, and now in his role as the Deputy Assistant Attorney General, were with us, they would remind the audience that over the past 4 years, all of the fraud section's FCPA enforcement numbers were up. The number of corporate resolutions, the aggregate amounts of corporate resolutions, as Dan Kahn, I think, said publicly yesterday, although there was a slight dip in individuals who were charged and guilty pleas over the last year, the unit still charged and convicted more individuals through a plea or trial in 2020 than it did in 2017 or in any prior year. And of course, those numbers have to be considered in the context of a global pandemic. There also were various milestones that were set, including largest aggregate penalties on record, record-setting cases, and other ways. So I don't think the statistics actually bear out the thesis that I know some commentators have advanced. And I think in part, when people are looking at the so-called decline in FCPA enforcement, often they're analyzing, for example, the number of public companies that have disclosed investigations, noting a decline in those numbers. It's a very imperfect metric. Obviously, the FCPA reaches beyond US issuers. So there are plenty of companies who are not subject to reporting obligations with respect to an FCPA investigation in the United States. And as many securities regulations lawyers would tell you, there isn't necessarily, it's a case-specific evaluation, but there isn't necessarily an obligation to disclose the existence of an FCPA investigation. Many companies make the decision to disclose for prudential reasons, but may feel that legally they're not required to, either because there's quantitative or qualitative materiality that's lacking. And so it's quite difficult, I think, to look at public disclosures and draw reliable conclusions about the pace and nature, severity, et cetera, of FCPA enforcement. I think looking ahead, we can expect FCPA enforcement, as I alluded, to remain robust, probably increase. I know that a common assumption is that, well, that's just to be expected, given that it's now the Biden administration, and we can expect some less business-friendly approach to enforcement. But I think I have a more nuanced perspective on that issue, and it relates back to what I said previously. A lot of corporate enforcement in the fraud section at DOJ is institutionalized. It's embedded in headcount and funding and organization and all sorts of things. So the FCPA unit, the fraud section, the criminal division, they have ongoing priorities for how to grow their program. It's obviously the case that many countries around the world suffer from endemic corruption. We have the Dodd-Frank whistleblower program that's institutionalized at the SEC. We have all the tools that Kendall has alluded to and that we'll be discussing today under the NDAA and the Money Laundering Act that was passed, which probably will mean just more tools available to pursue investigations in the corruption space using these other tools that are coming up in this other legislation. So I fully expect that things are going to continue and likely grow. Programmatically, there's been a lot said by the department about the rise of multi-jurisdictional and global anti-corruption cases, and the department will point, of course, to the Airbus resolution and the Goldman resolution as examples of that. Just yesterday, again, Dan Kahn said that we should expect a significant increase in these types of cases in the anti-corruption space. And that focus, and I think it is a real focus within the department on coordinated action, whether that's investigative or in resolution, with foreign enforcement authorities. It's really taking hold, and it takes hold in a lot of different ways. It's not just how an investigation is conducted and the level of cooperation that DOJ and the SEC are achieving with foreign counterparts. It's also at a policy level. We're going to talk today about what everyone calls the anti-piling on or the piling on policy. And the root of that at a very basic level is the desire for coordination, both with companies and with other regulators, to achieve the outcome of not gratuitously adding to penalties when penalties have already been paid. And I think, look, a focus on individuals will continue at the SEC, which we now have a person who has been nominated to lead the SEC, who is known to be aggressive on enforcement. One of the commissioners, Carolyn Crenshaw, just yesterday advocated for tying corporate penalties more closely to the egregiousness of the conduct, the extent of corporate cooperation, maybe less emphasis on the harm to investors that come from penalties and the consideration of whether investors benefited from the violation. So you have some currents over at the SEC that could be influential in terms of the enforcement climate. And programmatically, Charles Kane also has been speaking about looking at industries where that are not typical heartland industries, so to speak, for what you would think might raise issues under the FCPA, and looking at the schemes by which funds can be misappropriated and siphoned from companies and then used to pay bribes. So you put it all together, I don't think enforcement really has decreased, and I think it is very likely either going to remain stable or only increase in important ways in the years ahead.
Thanks, Steve. Turning to FCA enforcement, Chris, where do you see the department's priorities under the new administration?
Yeah, well, so fortunately, the department has been very explicit about its new priorities in this administration. In his first public remarks as acting head of the Civil Division, Brian Boynton, just last month, identified 6 priorities. And so the first will come as no surprise, which is pandemic-related fraud. The others, I think, also are probably not terribly surprising. In order, they're opioids, fraud targeting seniors, electronic health records, telemedicine, and cybersecurity. Taking each of those in turn, there's been a lot of commentary about the increased FCA exposure resulting from the CARES Act funding last year. I do think that any companies participating in that need to be very attentive to the eligibility requirements, their use of proceeds under the PPP and other programs, and then any certifications related to loan forgiveness, not just because those are traditional FCA theories of liability, but also because that law created an enhanced mechanism for IGs to conduct oversight, and DOJ has been very explicit about its desire to cooperate with IGs on that very issue. Opioids, we've seen huge, billion-dollar plus settlements in the opioid space over the past couple of years. DOJ has indicated that it intends to move beyond just the pharmaceutical manufacturers further down the distribution chain to pharmacies and clinics who participated in that. So I think that they've been very clear on that. I think electronic health records, fraud targeting seniors, telemedicine, that strikes me as sort of pretty consistent with what you see over the past several years, where healthcare makes up roughly 75% or more of FCA settlements. Those strike me as sort of, consistent with past practice. I think really the new frontier is probably cybersecurity. Just in the press, hardly a week goes by that you don't see some cybersecurity incident in the news, including those involving the federal government. And so I think the theory of liability there would be if the regulations or contracts, contain standards regarding cybersecurity measures that the vendors don't meet, it's not hard to see where the FCA liability arises. I do think those are really difficult cases to bring. I think that particularly after Escobar, there will be a question as to what in the contracts is truly material. And I also think that some of the supply arrangements where you have primary service providers, vendors, resellers kind of working under pretty elaborate contractual structures, that there are going to be questions as to whether any particular defendant actually caused the submission of a false claim, whether they acted with the requisite scienter. And we just don't really have a lot of experience with those cases. So to me, I think there's going to be a lot of defense side litigation on, particularly on scienter materiality.
Thanks, Chris. Lisa, with the incoming administration, what do you anticipate with respect to the department's antitrust enforcement efforts?
Yeah, so you, first of all, thanks, Justin, for having me with this terrific group of panelists. You don't have to be an antitrust lawyer to know that big tech is going to be a key focus of DOJ antitrust division. It started, obviously, in the waning days. DOJ filed a case against Google. I think you might have read about it in the newspapers, alleging that they were maintaining a monopoly in the search and advertising space. And you can only expect that to ramp up, both in terms of the folks that are being proposed for the antitrust division and the FTC. They've also talked a lot about more scrutiny on mergers between companies that might have previously approved. They might be in different industries, and yet a merger could create a problem. Interestingly, and I don't know that merger lawyers really think about this, but there's been an increasing trend where merger review has led to the discovery of cartels, criminal cartels. And unless they've moved, the merger floor was only about 2 floors below mine when I was chief of the criminal section there. And I think people maybe think that antitrust is a narrow space, but actually merger lawyers and cartel lawyers are totally different animals. And so oftentimes millions of documents are required to be submitted for a merger to be approved. And the lens through which they're viewed is quite different than the lens that a cartel lawyer would use. And so a key example of that would be the tuna fish cases. Actually, Bumblebee and Chicken of the Sea were looking to merge. They went for merger approval. The DOJ spotted that, in fact, they and Starkist had been colluding on the price of tuna for years. And so a major criminal investigation was opened. one of the companies sought corporate leniency and the other two pled guilty and have paid hundreds of millions of dollars in fines, and executives have been prosecuted and gone to jail. Most recently, the CEO of Bumblebee was sentenced to 40 months in jail. So even the civil side of antitrust can have real implications for the criminal side. No doubt, as everyone has said, enforcement is going to be up. There was really record low enforcement on all the criminal metrics in terms of number of cases filed during the Trump administration and the fines. When I was there, we were bringing in about $1 billion a year in fines. That dropped by as much as 90% in some of the Trump years. So there's absolutely no question, more resources, more prosecutors hired, more investigations happening. And a big switch, there had also been a real focus on the domestic market during the Trump administration. Chicken producers were prosecuted, and a big focus on government spending, which are great goals, but where those billion-dollar fines had come was because for 20 years, the division had really focused on the global economy and put its money, its investigation money, where the money was in terms of biggest impact on consumers in the US. So I expect a return to engagement and cooperation. The other two big places that I think we need to watch is really brought on in a degree by the pandemic. There's definitely been an increased focus on healthcare, as there should be. Already, healthcare was a huge segment of the economy, but with additional spending and additional monies I think, about to be allocated by Congress to go to COVID relief, that's going to be a space that that the Biden administration is going to be watching closely. The division announced early in the pandemic that while they would expedite approval of sort of joint arrangements between companies in an emergency, they would be watching closely for any kind of price collusion or coordination. And so I think that close watch will continue. Also, the economic pressures brought on by the pandemic invariably have an impact on a wide swath of industries. And I think most people think of price fixing as something where companies are getting together to raise the price, to make it higher and higher, get bigger and bigger profits. But in reality, a large percentage of Sherman Act cases that are brought are in a downturn in an industry where prices are dropping and when there's strong economic pressures, which of course the pandemic is bringing on many industries right now, right? And so companies get together, what I used to see in the documents we would get a lot was, we need to stop the bleeding. They're just, they're down at margins that they feel like they can't live with. So they get together and set price floors. And a price floor is every bit as much a criminal violation of the Sherman Act as raising prices. So I think DOJ is going to be looking closely at places where panicked companies kind of that maybe in better times would have known better than to get together and collude. They're going to be looking closely to see if that kind of conduct was going on. In the healthcare space, not only is it being looked at for the typical type of price fixing or market allocation offenses, but there have been 3 cases brought in the healthcare space just in the last 6 months. And they've been in an interesting area that DOJ antitrust historically did not pursue criminally. And that's agreements that have to do with labor and wages. In the late in the Obama administration, a huge policy shift was announced by the antitrust division and the FTC, saying that agreements between companies not to hire one another's employees, or agreements on what wages or compensation they would pay to employees, that those were going to be criminal offenses when previously they had always been treated as civil offenses. This has really caught companies completely flat-footed, and I hadn't realized until the change was made how many industries apparently this is not that uncommon. And so, and the awareness of this change from civil to criminal penalties possible just wasn't out there. And so several cases have been brought involving surgery centers, involving oncology centers, involving physical therapists, where the criminal allegations are that it was an illegal criminal conspiracy to agree not to hire one another's employees or to agree on the wages that you would pay. So I have no doubt, given the Biden administration's focus on labor and protecting workers, that this is going to be space that's just going to continue and explode to be where DOJ is putting its resources.
Thanks, Lisa. And you mentioned an increase or a likely increase under the new administration when it comes to international or cross-border investigations. Kendall, I'd be interested in your thoughts on this because recently DOJ's authority to seek documents from foreign financial institutions has been expanded. Can you tell us a little bit about that and how you see that impacting at all DOJ's enforcement efforts when it comes to cross-border or international investigations?
Sure, Justin. So that's exactly right. The Anti-Money Laundering Act of 2020 did significantly enhance the ability of prosecutors to obtain foreign bank records. Previously, there was a section under the Bank Secrecy Act that allowed prosecutors to seek records related to correspondent accounts of a foreign bank. So a foreign bank who has a correspondent bank account here in the United States, prosecutors could seek records related to that correspondent account. The change to the law, though, broadens the category of records to any account at the foreign bank. So it's no longer tied to that correspondent account. It's any account that a foreign bank may maintain overseas if that foreign bank has a correspondent account here. That now, under this provision of the law, is something that the prosecutors can potentially target. You know, in some ways, this is similar to Bank of Nova Scotia subpoena authority that prosecutors previously held. The difference here is under Bank of Nova Scotia, the Justice Department had put in place essentially a speed break, right? The Bank of Nova Scotia authority allows prosecutors to seek records of a foreign entity if that foreign entity has a presence in the United States, and to compel that production by holding the local entity in contempt. This is, though, a more direct hook. It basically is saying if you are, as a foreign financial institution, have a correspondent bank account, one of the conditions to continue to maintain that account is to comply with requests for bank records you might maintain that have nothing to do with that correspondent account. Otherwise, you could lose your correspondent account access. More international financial records is going to mean DOJ can bring more international cases, whether they're, to Steve's point, FCPA focused or money laundering focused, or even to Lisa's point, antitrust focused. They're just going to be able to accumulate more evidence.
And I'm curious, many, as you know, foreign countries have privacy laws or blocking statutes that essentially prohibit companies from disclosing certain types of information. Do you expect there to be litigation over the tension between those statutes and, say, a DOJ request for foreign financial records? We sort of saw this play out a little bit. I think it ultimately got resolved without a judge having to rule on it. But a few years back, there was that litigation between the SEC and Deloitte with respect to requests, I think, for records in China.
Yeah, so I do expect litigation. Now, that's different than saying, what will the outcome of that litigation be? As you pointed out in the Deloitte case and in other cases I'm familiar with, often the litigation leads to a negotiated resolution as opposed to kind of outcome determinative rulings by a court. Part of that is because those are difficult challenges to mount. If you are a litigant here in the United States, basically telling a U.S. court you don't have the authority to do something, that's a tough argument to be persuasive on. But I also think, you mentioned China. I'm sure, many of the people on this webcast will have seen that shortly after the passage of the Anti-Money Laundering Act and the National Defense Authorization Bill in China, there was a publication of rules about counteracting unjustified extraterritorial application of foreign legislation. Now, that didn't reference what had just happened days earlier in the Anti-Money Laundering Act, but that idea that other nations will enact blocking statutes or make it more difficult for their financial institutions to comply with process under this expanded authority prosecutors are going to have, I think that's a real issue, and it'll be difficult for our multinational clients to navigate.
Thanks, Kendall. Another relatively new development is that DOJ has utilized statutes other than the FCPA to pursue conduct which essentially amounts to foreign corruption. Steve, I'd be curious what you sort of made of that, or what you make of it, and how, and whether you think that this is a trend that's going to continue under the new administration, or just in general.
I think it will definitely continue. I think that prosecutors are resourceful, and generally, if you're looking to charge, let's say under the FCPA, but you have a jurisdictional issue or some other issue with one of the elements of the offense, you'll reach into your toolkit and you try to find other statutes that might be helpful. And I think DOJ is generally very good at doing that. And I think that you've seen, obviously, the effect of the anti-money laundering statutes being brought to bear. I think I have a statistic that between 2012 and 2019, DOJ brought enforcement actions against 57 individuals for money laundering connected to bribery. So this is now very much part of their toolkit. They'll continue to rely on it. They have relied on it recently, and they'll rely on it when it seems advantageous for them to do so, either because it augments something they're already doing in an FCPA action, or it allows them to charge in perhaps a circumstance where they might not otherwise be able to. And I think, again, I'd go back to some of the points that Kendall has been making. FCPA prosecutors are only going to have more tools at their disposal with this recent legislation. They're now, and Kendall can expand on this if we're interested, but there are new whistleblower programs. There's the Kleptocracy Asset Recovery Rewards Act pilot program. There's a Bank Secrecy Act whistleblower program. The AMLA itself makes it a criminal offense under certain circumstances for basically misrepresenting or falsifying or concealing, et cetera, circumstances where senior foreign political figures or their family members or associates are the source of funds in a transaction. There's new authority, as Kendall has alluded, for the Treasury Secretary and the AG to subpoena certain foreign bank records in the way that has been described. So there are a lot of additional tools that are coming online, which will be helpful to DOJ prosecutors in their investigations, in addition to the substantive liability that can result under the anti-money laundering or fraud statutes or other statutes.
Thanks, Steve. Chris, I wanted to ask you, when a member of DOJ's leadership speaks at an event or provides remarks, we all try to, extract some perspective from it. I wanted to ask you about a comment that Michael Granston made when he was recently discussing FCPA enforcement efforts of the department, where he predicted that DOJ will increasingly rely on data analytics to identify potential fraud cases and initiate investigations. What do you make of that, and how do you think that's going to impact DOJ's investigations and the types of FCA cases they ultimately bring?
So I do think it's worth paying attention to that. I think Michael Granston made those comments at the end of last year in December. Brian Boynton, in some remarks in February, doubled down on those, underscored that DOJ would in fact be using data more heavily to pursue FCA cases. So I think it's something to watch. I guess I would make 3 points. One, I think it's probably going to be most relevant in the healthcare sector. That's just an extraordinarily data-rich environment where the data is available to identify trends, identify extreme outliers or clusters of suspicious activity. So I think it is probably going to be most relevant there. And conversely, or by implication, I think it will probably be less relevant to some of the cases that we see coming out of the CARES Act funding. My expectation there is that a lot of those will be pretty traditional cases where whistleblowers and participating companies will be able to identify those, a company that was not eligible to participate, a company that didn't follow through on its representations, reduced its headcount beyond the way that it was, supposed to. And those, it doesn't really take a lot of data to identify those cases or to bring them or win them, because I think those are individualized transactions or sort of firm to firm. Second, I think it really can affect how companies participate and cooperate with DOJ if there's a CID, a civil investigative demand, because I think if you've got a case that's based on data and you're in a cooperative posture with DOJ, there ought to be a way to say, look, let's stage this investigation so that we, start with a relevant cross section here, and you sort of would look at whether it's geographically, chronologically, wherever this sort of suspicious activity was, and sort of contain the relevant discovery, witness interviews, and so forth around that, and then see where to go. So I do think it can be useful on the defense side. I also think that, for a data heavy case, for firms representing clients in CIA investigations, it's worth considering whether to bring on an expert, at least a consulting expert, to sort of help think through, where there may be cross trends in the data or alternative explanations than what DOJ is pursuing in a data heavy case. I think the third point I would make, it's sort of taking a step back from that, which is to say that if DOJ is going to be focused on data analytics, and as we'll talk about later, I suspect, DOJ is also interested in looking at the effectiveness of corporate compliance programs, it's not hard to say, look, our corporate compliance programs should also be data-driven. We should have a way internally to identify data anomalies, outlier doctors, outlier clinics, outlier facilities, et cetera. And to incorporate that sort of data analytics into the compliance program, I think can be a virtue, both in terms of reducing FCA issues on the front end before they arise, and then in the event that you find yourself in a posture adverse to DOJ, you can cite them to say, look, we have the ability to run data anomaly reports. We have a team that looks through these things and pursues them, because I do think that it's sort of part of an effective compliance program these days. So that's what I'd say about that.
Thanks, Chris. So it wouldn't be a panel on white collar enforcement if we didn't talk about some new task force or strike force. Lisa, I wanted to ask you about the procurement collusion strike force, which DOJ stood up not too long ago. Can you tell us a little bit about that and how you see that influencing the department's antitrust enforcement efforts?
Yeah, absolutely, Justin. That was actually started shortly before the pandemic. And what it was is it was initiated by the antitrust division, but they joined forces with the criminal division. I think 12 U.S. attorneys' offices are part of the strike force, as well as FBI, DOD, postal inspectors, and quite a few law enforcement agencies. And the idea is to just have folks that are especially focused on looking for bid rigging and other collusion that's impacting government agencies. It's something that's sort of been done once every decade or so, but it was particularly timely here because it was launched just about the time that the pandemic hit. And now, as we said, and as we all know, tremendous amounts of government spending are going to be happening, not only from the COVID relief bill that'll be pumping out incredible amounts of money, but what we expect next on the horizon is the infrastructure bill that is looking to spend, again, tremendous amounts of money in the building and construction space, which historically has been a very popular, shall we say, area for DOJ antitrust to find some problems along the lines of bid rigging. So, and again, it's not a new idea. In 2008, with the Recovery Act, antitrust had stood up a similar kind of task force. And what they did was go out and train like literally thousands of agents and IG professionals and auditors with what was called the red flags of collusion. Just sort of some easy, gave them a little card they could keep on their desks to just sort of recognize patterns in bidding that look suspicious, and then a phone number of who to call over at the antitrust division. So they no doubt are going to, I think, not only keep that up, but probably expand it again with the amount of money, just as day follows night, when the government is spending money, bid riggers and folks figuring out how to defraud it are going to come forward. And the places where it'll be particularly looking closely, I think, again, in the healthcare industry because of all the spending there, and in the all the sort of products that we maybe didn't even know we needed before, like hand sanitizers and masks and gloves, and places where there's just kind of a sense of urgency. And that's kind of when things get sloppy and it's easy for for collusion to happen or to be overlooked because everyone thinks I'm doing something good, I'm getting hand sanitizer out, I'm getting masks out. But that's when, unfortunately, as we all know, some folks in some companies take advantage of the situation. So I expect it to continue and probably be busier than ever in the coming couple of years.
Thanks, Lisa. Kendall, I wanted to ask you about, you'd mentioned earlier the new AML whistleblower program, and Steve had alluded earlier to the fact that these whistleblower incentive programs have over the years become an effective tool for prosecutors and regulators in identifying areas for new investigations. Can you tell us a little bit about the program and how you see it potentially impacting the government's enforcement efforts in the anti-money laundering area?
Sure. Look, I think this is potentially a very big deal. So what the expanded whistleblower program allows is that in any AML enforcement action brought by either DOJ or Treasury, where the monetary penalty is more than $1 million, the Treasury shall, and it's not discretionary, it uses the word shall, pay an award of up to 30% of what was collected to whistleblowers who voluntarily provided original information. There previously had been a whistleblower program, but it was quite modest. In most cases, it capped awards at $150,000 and was discretionary. So already you're talking about a baseline $300,000 award or more at that 30% of the $1 million floor. In my experience, the more modest amounts really aren't enough to generate significant interest. Becoming a whistleblower is not a great necessarily career step. And so for those whistleblowers who are thinking about, life after reporting, it's going to make a difference that there's the potential for a very significant recovery at the end of the process. Steve mentioned earlier in the FCPA enforcement context, the Sarbanes-Oxley whistleblower reward program for 2010 with the SEC. And I think that's a great analogy, right? So when that program came into effect, from that program till now, the SEC Office of the Whistleblower has received, I think the latest data I saw was something like 40,000 tips from every state in 130 countries around the world. And there have obviously been very significant SEC whistleblower awards, which only generates more tips and more interest. I think that's the kind of dynamic that could happen here. The establishment of a plaintiff's bar to help whistleblowers navigate the process to make a report and then collect on any reward. The other dynamic that's at stake here is the pool of people who potentially could make a whistleblower complaint in the AML space is enormous. At financial institutions, there are often hundreds of people in the anti-money laundering compliance space. Has this effectively weaponized, even low-level employees' ability to contest a decision by a financial institution not to file a suspicious activity report? This program isn't in effect yet, but I think once the Treasury Secretary implements it with rules, this is going to be a big deal.
Thanks, Kendall. Chris, for years, cooperation credit has been a key component to corporate resolutions and white-collar enforcement matters, but historically, when it came to FCPA settlements, the department hasn't included a formal cooperation credit component. That's recently changed, though, through formal DOJ guidance. Can you tell us a little bit about that and, in your experience, how, if at all, it's impacted resolving FCA matters with DOJ?
Yeah, so just the background here is in May of 2019, DOJ announced a formal cooperation framework for the FCA. And, I don't think there's not a lot of surprises in what that, program contains. It rewards self-disclosure is the most significant consideration. That was, of course, in the FCA statute already, that you got statutory benefits from that. And then the other significant criteria are taking remedial steps, improving compliance programs, identifying knowledgeable individuals, and then sharing data in particular where it requires access to specialized or customized systems. And then, the benefit would, of course, come in the form of, reduced damages. I would say that, I think the real benefit to this is sort of providing a framework for both discussions on the client side. Here's what we need to do to cooperate and remain in a cooperative posture with DOJ. Those can be difficult conversations depending on the client. So I think it's very helpful to have an explicit framework from the department to enable outside counsel to have those conversations. And then I also think it's helpful in terms of interactions with the department in terms of seeking credit. I will say that the policy is less than 2 years old, or the announced policy, and it's not sort of clear, at least I think empirically, how much credit you really get under this framework than you would have received previously. I think, anecdotally, we all have experience with a good relationship with DOJ in particular matters, but I think if you look empirically, it's a little hard to tell whether the damage multipliers are in fact going down.
Thanks, Chris. And just staying on that topic, the topic of corporate resolutions for a moment. A couple of years ago, the DAG at the time issued guidance and instituted changes in the Justice Manual that essentially encouraged coordination among department components and other enforcement agencies when imposing multiple penalties for the same conduct. This was the anti-piling policy that Steve mentioned earlier. I'd be interested in the panel's thoughts on how that policy has sort of played out as a practical matter, and whether folks think that anything will change under the new administration with respect to that policy or any other charging policies for that matter.
I guess just talking about the anti-piling on policy for a moment. I think it is a laudable attempt to impose order in what is an increasingly, balkanized enforcement landscape, or potentially could be. What's notable about the anti-piling on policy is sometimes the limitations of that policy, right? It's a directive to prosecutors. It doesn't speak to other federal agencies. Although obviously there can be some coordination between DOJ and those other agencies. And it certainly doesn't limit international enforcers in any way, or enforcers at the state level. And there are even recent examples where at the federal level, the anti-piling on policy hasn't resulted in a reduction in the penalties that are being paid. The whole point of it, I think, if you had to sum it up, is if you've got multiple enforcers all looking at similar conduct, just because there are multiple enforcers doesn't mean that the penalty that the entity will pay needs to go up. Instead, each of those enforcers should reduce their penalty in order to take account of the penalties being imposed by others. But in October, the most recent example I'm aware of, there was a resolution with a Chicago-based company, a distiller, where there was a DPA for FCPA violations, and the company paid a $19.5 million fine. And at the same time, as often happens, it resolved FCPA allegations with the SEC. But the settlement agreement in that even made clear, the DOJ's deferred prosecution agreement, that there was no reduction for the penalty paid to the SEC, because in DOJ's words, the company did not seek to coordinate a parallel resolution. So in some ways, it put the onus on the company to coordinate, where if you take a step back, you could see from a policy perspective, the onus maybe would be better placed on the prosecutors or on the government actors who have more control over that process than does the entity that finds itself the subject to those inquiries.
Kendall makes an interesting point. I think that this policy reflects at some level, I think, good faith intentions by the department to address the issues that Kendall was alluding to. It also does reflect certain limitations. I think that one thing I'm ready to say is that I believe that the department is committed to faithfully implementing the policy and committed to seeking coordinated resolutions in ways where the penalties are rationalized in the way that intended by the policy. I think the department's expectation is that it's a two-way street, and that if you are a company that is looking to get the benefits of the policy, you're also a company that will involve the department early on. And if you don't involve the department early on and seek, for example, to try to resolve all your civil exposure, for example, in the first instance, and then go to the department and say, okay, well, now I want credit essentially for what I've already paid out under in my civil regulatory resolutions, I suspect that's not going to be met with a lot of positivity from the department. So it's one of these things where it's a policy that can work. It can work, I think, and it is working in certain cases where there is that mutuality of in spirit in terms of coordination between companies and the department. I also think that where it really gets tricky is if you're representing a company and you're trying to advise your client on the potential benefits of this program, there are certain countries around the world where we now have plenty of examples of good cooperation between US enforcement authorities and foreign enforcement authorities. UK, France, Brazil, others. But there are many countries where we don't have any examples of that. And sitting in your office chair, you probably would say, well, either I have no idea whether a cooperation at this moment could even be achieved between the US and that other country. Perhaps rule of law is not what it is in the other country as it is in the US, or there's some diplomatic reason why that can't be achieved or otherwise. And so it gets tricky to advise a client in operating in countries potentially with an issue in a country where there isn't that track record. And the rubber really hits the road when you get to discussions about, for example, voluntary disclosures, which is probably could be a whole other panel, as it often is. But just think about it, when you're talking to a client and you're a company considering whether to make a voluntary disclosure, one of the concerns is, well, how can I be assured that I'm not going to get whacked by X other regulator or in X other country? And some comfort can be given depending on the case, depending on the country, based on this policy. And oftentimes, though, comfort cannot be given. And so that ends up weighing into decision making with respect to voluntary disclosure.
Steve, I wanted to ask you about another policy memo that has impacted, or at least was intended to impact FCPA enforcement actions, which is one on corporate monitorship. So for years, they've been a staple of FCPA enforcement actions, but the prior administration issued a memo essentially indicating a reluctance to impose corporate monitorships. I guess, were you surprised by that memo? And do you think that there'll be a shift in policy under the new administration where they'll be more inclined to impose corporate monitorships as part of FCPA resolutions?
I wasn't surprised by the memo in the least. I think the memo is consistent with the orientation toward business that I think we can all summarize from the prior administration. So the memo didn't surprise me in the least. I understood the presumption as it was being articulated by the former Assistant Attorney General against monitors. Of course, the change in policy still allowed for monitors, but I think you're right. There was definitely a presumption, if certain factors were met, that there would not be a monitor. And I do think that in a Biden administration, this is an area that could certainly receive attention again. And I do think that you could see the pendulum shifting somewhat back toward greater likelihood of monitorships in certain kinds of cases. Obviously, I don't know how that might play out. You could say that at a certain level, if you look at the monitorships that were imposed in the FCPA space in recent years, it's generally predicated on a trust but verify type of model. You could still have a trust but verify model, but the verifying could be a lot more and the trusting a lot less. So I think we can expect that to be an interesting discussion, certainly in the defense bar, and we'll see what happens at DOJ.
Lisa, I wanted to ask you briefly about the recent policy change in the Antitrust Division's leniency program and how you see that impacting things going forward.
Yeah, so historically, for decades, the Antitrust Division was kind of an outlier in the sense that they would never resolve a corporate criminal investigation with a DPA. And the reason was they had their own unique program, the corporate leniency program. And what it says is, and it can offer it because by definition, a company must be colluding with other companies in order to have committed an antitrust offense. And so the first company, and only the first company that comes forward, can get a non-prosecution commitment from the DOJ and all of its executives for having participated in a cartel. And the concern was always that any other option, and this, they wanted to keep it very stark, either a guilty plea or you're the first one in the door, in order to motivate people to come in quickly. In fact, they talk frequently about a race to the prosecutor's office. And I myself, when I was there, had 2 different phone calls 45 minutes apart. One company was the successful leniency applicant and got no penalty whatsoever. And the other one, paid several $100 million and 6 of its executives went to jail. So the race is true. But they were always worried about the availability of a DPA, which could be obtained years into a cartel investigation, would weaken the value of leniency. But then they started breaking down that rule with exceptions. With the LIBOR and foreign exchange rate cases involving the banks, they realized that in a heavily regulated industry, with all of the ramifications that there would be if they had to take corporate guilty pleas, they made an exception and offered DPAs there. Then again, in the last couple of years, there was a big investigation in the generic drug industry. And there, if these companies were debarred from participating in Medicaid and Medicare, they would have been industry destroying moves. And so they allowed DPAs there. And so likewise, the division had never really given credit for compliance programs. Again, it was because almost always high-level executives were involved in the conduct, and the thought of giving credit would be almost meaningless, because how could it have been an effective program if your president and your CEO were involved in the collusion? So, but then the division heard critics saying, well, then what is the motivation to have an effective compliance program? So now the division right now they have a much more nuanced approach. Of course, they still hope companies will come in for corporate leniency and still tout that as the best choice. But they are considering DPAs even beyond very regulated industries. They recently gave one to a company in the ready-mix concrete industry, just because one of the things they emphasized was that they had created a very A+ compliance program. So there's criticism now that this has weakened the leniency program, which for years was the driver of those billion-dollar fines and 100 cases a year. So I think the Biden administration is going to step back and take a look at these changes. Are the options encouraging the things we want to encourage, like creation of effective corporate compliance, or are they actually weakening what has been the biggest driver of effective criminal antitrust enforcement, which has been the division's corporate leniency program? So it'll be interesting to watch as the new AAG comes in, which way he goes, or she.
Thanks, Lisa. So I was just taking a look. It looks like we're at the top of the hour here, so we should probably wrap up. I want to, again, thank the ABA and our panelists for an informative discussion, and thank you to everyone that attended. Maybe we could all reconvene in a couple of years and compare notes and test some of our predictions. Until then, stay safe and healthy, everyone. Thank you and take care.
Thank you.
Thank you.
Bye-bye.